Hello, my name is Isabel Alzate, and I am here to present two cases that have changed the way that the U.S. Supreme Court sees defamation. The first case is New York Times versus Sullivan. L.B. Sullivan, who was a commissioner in charge of supervising the police department of Montgomery, Alabama, sued the New York Times because of the inaccurate portrayals of the police department in the full-page ad, Heed Their Voices, that the newspaper had published. He declared that the ad defamed him because of how they portrayed the Montgomery Police Department, even though he was not named in the ad. The elements for defamation, libel, in this case, were the false statements in the ad placed by the New York Times. Sullivan was a public figure because he was Commissioner of Public Affairs, and he wanted to prove that the New York Times published the statement knowing that it was false or without caring if it was false. The U.S. Supreme Court voted in favor of the New York Times due to the fact that a state cannot, under the First and 14th Amendments, award damages to a public official for defamatory falsehood relating to his official conduct unless he proves actual malice, that the statement was made with knowledge of its falsity or with reckless disregard of whether it was true or false, meaning that public figures like L.B. Sullivan could not sue a news publication for written defamation, libel, unless they can establish actual malice in the news story with false information. In this next case, GERTZ'S versus WELCH, Elmer Gertz was the petitioner and the respondent was Robert Welch, Inc., owner of the magazine American Opinion. An article was written in American Opinion claiming that he was a communist because he represented the family of a boy who was killed by a police officer in a civil lawsuit in 1968. Gertz was accused by the American Opinion article as being in a Marxist League for Industrial Democracy, originally known as the Intercollegiate Socialist Society, which has advocated the violent seizure of our government, a Leninist, a communist frontier, and that he had a criminal record, as well as more comments on his political stance and having no proof that this was the case. Evidence was collected and there were found to be many false facts in the article about Gertz. For example, that he had a criminal record. He was also confirmed to be a private citizen rather than a public official or figure. The only reason that he became a public figure was because of the article. For private individuals, states may not impose strict liability on news media, but any standard of fault lower than recklessness limits private individuals to awards for actual injury. These allegations of being a communist hurt Gertz's reputation as a lawyer and a citizen because it would have made people hesitant to hire or speak to him, given the political climate of the late 1960s and early 1970s. It would have made law firms a bit uncomfortable hiring or working with him due to all the negative publicity. What I would have done differently to Welch was to actually verify that the statements in the article were factual and not false. I would have also had two different journalists covering the Nuccio case, the case of the police officer who shot a young boy, in different angles to gain the complete picture, and I would have requested an interview with Mr. Gertz himself. The elements of defamation in the state of Florida are that the defendant published a false statement about the plaintiff to a third party which caused harm or injury to the plaintiff. Florida is one of the few states that recognizes criminal libel such as prohibiting falsities regarding a financial institution's reputation. A private person, plaintiff, who files for defamation must prove that the defendant acted with negligence of false defamatory statements, while a public person must prove that the defamatory statements were made with actual malice. The statute of limitations for defamation in the state of Florida is 2 years. What I have learned from both the Sullivan and Gertz cases are the different defenses a public official like L.B. Sullivan has to use in contrast to what Elmer Gertz, a private person, has to use. A public person, whether a figure or official, has to prove actual malice in order to win a defamation case, while a private person has to prove that the defamer showed negligence in considering that a statement is false before being published, more so than reckless disregard. Negligence is conduct that creates an unreasonable risk of harm based on behavior of a reasonable person in like circumstances. I also have learned that whether as a journalist or a public relations professional, I have to be careful of what I publish and make sure that all the facts are correct. I would have never imagined that cases like New York Times versus Sullivan and GERTZ'S versus WELCH Inc. would have become landmark cases and set the standard for future defamation cases. I feel honored that I had a chance and opportunity to learn more about them, because it gives me a chance to learn more about the First and 14th Amendments to help my career as a professional in both the entertainment industry and public relation world. Thank you so much and have a wonderful day.